Until the mid-late 2000s, provincial birth registration forms relied exclusively on the categories mother and father, echoing the gendered basis of common law presumptions of legal parentage. Following legal decisions in BC, Ontario, and Alberta, stating that the exclusion of non-biological lesbian co-mothers from birth registration forms was discrimination on the basis of gender, provincial vital statistics regimes made incremental changes to the forms, including adding terms like other parent or parent, as well as or sometimes in place of father, in addition to the mother as registrants. However, birth registration forms remain structured so as to presume that the person who gave birth is a mother and then could not account for gestational surrogacy arrangements, where a woman carries a child not genetically connected to her for intended parents. Participants in gestational surrogacy typically turn to the courts for declarations of parentage and non-parentage that would then reflect their intentions. In 2017, Ontario's new legislation on determining parentage came into force, providing definitions and setting out conditions in such a way as to allow all children born through various assisted reproductive methods to be directly registered as children of their intended parents. In this paper, I consider how the new forms invite and construct knowledge of surrogacy, surrogates, birth-giving, and parentage. I focus on gestational surrogacy because in its ability to separate pregnancy and birth-giving from genetic connections between a person, gendered female, and a newborn, it highlights what we understand of pregnancy and birth-giving in and of themselves. Birth registration forms circulate within layers of gendered social and legal frameworks. While gender is recognized by many as socially constructed, understandings of pregnancy as something only women do remain dominant. Despite growing acceptance of changing gender roles, much social caregiving work, including caring for children, remains gendered, often racialized and underpaid. Further, pregnancy may be perceived, both by a pregnant woman and by society, as a caregiving relationship wherein the fetus receives care by and through a pregnant woman. This caregiving aspect might be emphasized where a woman becomes pregnant knowing that someone else is the parent of that child. A second layer of circulation is the gendered aspect of the common law presumptions of parentage. So the common law presumed that she who gives birth is the mother. This presumption relies directly on an observable natural fact, giving birth. The common law presumptions of fatherhood, however, are based on a social relationship between a man and the woman giving birth, or the person giving birth. Thus, if a man was married to a woman at the time of birth, or in the case of divorce and widowhood at the time of conception, roughly, he would be the presumed father. These gendered presumptions of parentage are still part of the law of most provinces, although marriage is no longer required. It's based on living together, and the presumptions are rebuttable through DNA testing and have been since about the 70s. Roxanne McKitty explains that common law presumptions are based in ideologies of the family as heterosexual and married, yet also natural in that this type of family reflects what is minimally required for biological procreation. The common law of parentage then conflates what appears as natural kinship with hegemonic and also contested social affinities within which children are to be raised. Birth registration practices, as well as circulating in these areas, are also closely linked to legal constructions of custody, parentage, family, and caregiving relationships. These are all highly gendered, despite the gender neutrality found in statute and case law. In an analysis of intentionality and gender neutrality in custody cases, Susan Boyd explains that judges tend to give less importance to the parenting intentions of non-biological lesbian co-mothers and gestational surrogates commissioned by heterosexual parents than to those who have genetic connections supporting their intentions to parent. This gendering can also be seen in judicial trends towards recognizing known sperm donors as parents in disputes with women-led families, led by single women or by lesbian co-mothers, thus finding fathers for families that are judicially perceived as incomplete. To those layers, I'd like to add a final layer, which might be understood as social relations between gestational surrogates and intended parents. Gestational surrogacy, while disrupting the construction of the natural family still relies on stereotypes of women as bodily nurturing and bodily giving. Relations between gestational surrogates and intended parents can take many different forms. Sometimes people know each other. Sometimes people are paid. Sometimes they're not paid. They're not supposed to be paid in Canada. And they involve all kinds of different people. One study emphasizes the role of trust between the parties, arguing that surrogacy arrangements are a consumptive kinship practice, which results in interesting dynamics of contract talk and trust necessitated by the very nature of surrogacy as a collaborative process. A Canadian surrogacy lawyer explains to prospective clients that the surrogate and intended parents are choosing each other and that this is the beginning of a relationship. Studies of gestational surrogates show that while factors such as her own social relationships and how the pregnancy is physically progressing are significant, the quality of the relationship with commissioning parents is key in shaping gestational surrogates' experiences. Most of these relationships were good, according to the women who acted as surrogates. And Campbell notes that a surrogate's satisfaction seems to be enhanced when she and the intending parents have shared expectations about their respective roles and responsibilities. And one study found that for women acting as surrogates, being treated with respect, honor, and care by the commissioning parents was of utmost importance to them. All felt that they were doing something unique and wanted the immensity of what they were doing to be appreciated. A minority of gestational surrogates in these studies, however, felt used if they had received promises of or had expectations of continued social contact that were not fulfilled. Where women acting as surrogates felt that the commissioning couple did not appreciate sufficiently the extent of what had been done for them, they regretted their involvement. So these are the contexts within the new birth registration forms are circulating. In Ontario, birth registration is a two-step process. The Notice of Live Birth Form 1 is filled out, signed, and submitted by the birth attendant. It names the mother and provides details like date of birth, weeks gestation, weight of the child. The Statement of Live Birth Form 2 is filled out, signed, and submitted by those who will become parents of the child. And here details include things like the name of the child, the names of the parents. Birth registration forms are important because they provide the first legal organization of the knowledge of intrafamilial connections with a new legal person. But birth registration is much more than a legal event. In Rutherford, the Ontario Court of Appeal analyzed the purpose of birth registration and tied the legal presumptions of parentage to the social acceptance of lesbian families, stating that the benefit sought under the Vital Statistics Act is access to the benefit of being able to register both intended parents as of right, with the resulting presumption of parentage, or access to the social and symbolic institution of having their names on the birth record at the first instance. So birth registration is both about being recognized as parents to make medical and educational decisions in a legal framework, as well as the social and symbolic effects of recognition as a family. We can think of birth registration as a classification system that organizes the world spatially, temporally. Boker and Starr explain that any classification involves unique categorizing principles, develops mutually exclusive categories, and ideally provides total coverage of the world it describes. That's just an ideal. So the documents that do the work of this particular classification system are form-filling documents. They require responses by individuals who find themselves involved somehow, giving birth, being intended parents, being a birth attendant, or working at a vital statistics agency. Form filling is the moment at which persons responding to the form shape their experiences and knowledge of the birth event and parentage into the frames and categories on the form. They're also a space where individuals interact with significant sociocultural identifiers such as mother, father, and parent, as well as the legal definitions, bureaucratic definitions of those terms. So Heimer explains that forms, in setting categories that are meant to apply to various form fillers, induce selective attention and hide some facts while making others observable. Boker and Starr state that ordinary biases about what should be visible are active in classification systems. So while the frames, instructions, and categories on the forms might be constrictive and disciplinary, there is also agency in filling out these forms in terms of how they launch persons into desired aspects of certain identities. So what we have here is a meeting between these layers of gendered social activities and legal constructs and forms that are meant to free registrants from some of those constructs. So we'll have a look at the forms now. And both the, okay, so you can look at the forms. The dates are in the top. Both the 2016 and 2017, if anyone didn't get here, and anyone who needs one, if you can share.
Rachel, if you just move the mouse, this thing stopped flashing new pictures.
Right there. Okay. Right. So both the 2016 and 2017 iterations of the Statement of Live Birth begin with Section A, Child's Information, almost identical on both forms. The 2016 form has sections entitled Section B, Mother's Information, and Section C, Father/Other Parents' Information, set beside each other. And the questions that are asked, again, almost identical for both. The sections changed in 2017 and are now both entitled Section B or Section C, and you can see the check boxes. You can check off mother, father, or parent. This ostensibly allows for each of the parents the same range of choice in how to identify themselves. However, Sections B and C refer to different sets of instructions with which both frame parentage in terms of birth giving, the parent who gave birth and the parent who did not, with an exception for surrogate births. The instructions reinscribe gender through the focus on birth without using gendered terms. So, the Section B parent has to include, according to the instructions, the details of the person who gave birth to the child birth parent, unless that person's a surrogate. If a surrogate gives birth, she should not certify the birth, and either intended parent's details can be listed in Section B. As for Section C, that section has to include the details of a person certifying the birth who is not the birth parent and is a parent to the child, again with an exception for surrogacy. And if the Section B person is a birth parent, the Section C parent has to be the biological parent who is acknowledged by the birth parent, the spouse of the birth parent also acknowledged by the birth parent as a parent. Yes, that's enough. Section C disconnects the common law legal presumption of fatherhood from a presumed sexual connection with the birth parent. Indeed, the birth parent's intention to parent with another person are privileged and framed as gender neutral, even though that person's marital status, the person in Section B, is still required. The instructions for the form echo then the historically unquestioned and gendered common law presumption that she who gives birth is a parent, mother, while strengthening in some ways the birth-giving parent's autonomy in co-parenting decision-making, like about who to parent with. Section D in both iterations is called birth information. In 2016, there were no instructions accompanying this section, and it requests residence, total number of children born, weeks gestation, weight of the child. In 2017, identical information is requested, but the form filler is directed to instructions which newly frame birth information as collected for statistical purposes. The relevance then of a particular birth event to the record, the completed form, is socially minimized. The purpose of such information is only to be aggregated. Okay. Also, if the person in Section B is not the birth parent, they should only complete the mailing address and the birth attendance details, and are directly advised not to complete anything related to the birth event. Gestational surrogates and intended parents alike desire the legal outcomes of filling in the forms. Intended parents can use this document to show a legally recognized family. Surrogates can avoid legal responsibilities. I'm going to skip the part about judicial directions of, well, no, I'm not. So in judicial decisions granting declarations of parentage and non-parentage, intent and consent of all parties was key, with judges turning to ideas of genetic relatedness not to directly determine parentage, but to assist in separating birth-giving from parentage. The changes in the Statement of Live Birth continue that work. So in the courts, the ability to de-link birth-giving and parentage arose from judicial narratives of events over time based on parties' individual affidavits. The new forms accomplish this not through individual narrative, but by breaking down the once conflated birth giver equals parent category. The new forms, the forms design, when you can choose between mother, father, and parent, they support the ability to choose a parental identity and enable a counter-hegemonic engagement through offering commensurability of categories. Commensurability in these categories frees ideas of parental identity and visibly values all parent categories and all methods of family formation. Okay, so that's that. Section B now includes the question, as you can see, surrogate birth, question mark, accompanied by yes, no checkboxes. So this visual, as well as the instructions, direct all form fillers to respond to this question. This means that gestational surrogacy has become very visible. And that at the same time, it renders all ways of coming to the world equal for children. And it also makes the separation of birth giving and parentage visible. I can do it. So while the practice of gestational surrogacy has become visible through that question, surrogate birth, the instructions for registering the birth render the birth giver as an individual socially invisible. This is because the details of birth in Section D on the 2017 form are left blank in surrogate births. Recall that such details combine information about the birth giver's gestational experiences, such as length of pregnancy, number of children ever born, with that might focus more on the newborn, such as birth weight, birth attendant. These details, I see this information as kind of shared. These details evoke a past that led to the birth event. And if that was included in this form, as for a birth giver who intends to parent, connect to a present and future parent-child relationship. So accompanying the commensurability of parental categories is a commensurability of birth givers as individuals. The apparent commensurability of the category, the ability to choose to register as a type of parent that reflects one's identity, is different than the commensurability assigned to gestational surrogate. Details of a birth event are relevant only to those who give birth and intend to parent. Without that intention, the past of gestation and the birth event are irrelevant. So like so much gendered caregiving work, the gestational and birth-giving contribution of a specific person on the form is intermediary and does not need to leave a trace. In this way, the form becomes specific only to the future, to a particular parent-child relationship, at the expense of recognizing one of the people, typically identified as a woman, who contributed to the presence of the child. Now, I will go very fast to a kind of conclusion. If the gestational surrogate has no desire to be a legal parent to this child, then why is it of concern that her name doesn't appear on the statement of live birth? 2 reasons. The lack of her name reveals how gender neutrality and category commensurability are supported by the erasure of social experience that is gendered female. Okay? The second reason is, I could go into that, but the second reason is that gestational surrogacy is still a new and unique social practice. And in the studies I mentioned earlier, we note that some gestational surrogates regret their involvement when relationships with intended parents suggest that intended parents did not recognize their significant contributions. One way that social recognition can be provided is to, we need to recognize the person who acts as a surrogate as well as the practice of surrogacy, okay? So I suggest that if the intention of the new legislation is to socially value all methods of creating families, then the birth registration forms need to find a way to equally value surrogates' contributions. That doesn't mean that being on the birth record has to make you a parent.